if we know that they are not right or unconstitutional, we need to make
if
a
we
change.
know.
And we know.
We do know.
No, we don't. I'm sorry.
We clearly...
Some of us may feel that we know. I'm not sure that everybody feels the same way.
Well, no, the issue's black and white here, that our let me ask this question first. Do we agree that we allow signs larger than political signs in our regulations? I think let's address that. And Bob, I don't want to run, I'm not trying to run the meeting for you.
You're doing a good job.
Well, through you, I would like, if you would request a poll of the commission about that one question.
That question is?
The question is, do we allow signs larger than political signs in town?
And I don't believe that that's
do we allow or do we have?
Do we allow?
We have them. So right away, yes.
Some of which existed before we had zoning too.
Well, if you give me a moment, I'll give you the actual...
Well, you don't have to go through it. I mean, why don't you take a vote on it?
Now let's have a sense of the commission as to whether or not we have a constitutional matter here that would preclude our acting through the ZEO.
I don't think we can do this.
John?
I'm uncomfortable before we even get to that position. I think in order to enforce something against somebody, we need to know what the violation is and that each leg of the violation has been established. I don't know that it's a sign. It could be a fence. It could simply be a structure, an erection, anything you like to call it. And I don't see that it's necessarily a sign. Then you have to show that it is a political sign. And if it is somebody simply being bad-tempered and cross with somebody in town because of the way they think they've been treated, that is not necessarily political.
Oh, but it is, though, according to what we read. I mean, all the case law that we just had, a lot of it dealt with the same type of thing.
Ron, you misunderstand slightly that if I put up a sign on my lawn saying that you suck lemons, it is not necessarily a political sign. It may be a statement of fact. And before I'm going to enforce somebody, something against somebody, we should be sure that it is a political sign. Because if it isn't a political sign, then there's no violation.
Well, it goes back to the right to freedom of speech on private property, which makes it a political statement. Because it's a freedom of speech.
You know, I think that you've got to go through all the things to make sure it's, you know, that it is in fact a violation.
I think moving forward with this, you're on very shaky ground.
Ed?
Well, I think we've got to use common sense. He knows what he's doing, and we know what we're doing, but if we don't have a leg to stand on, we better spend some time on the sign regulation and the political thing before we take action on this.
Going back, since you've polled everyone, I think we have an issue. I'll give you a specific example. Page 82, 7.5.12, F as in Frank. This is signs permitted in middle quarter. They shall not exceed 24 square feet. So let's go back to our previous conversation with our attorney tonight in this legal opinion. If a business sign is allowed for 24 square feet and a political sign is allowed for 12, we have just contradicted our own attorney's advice. There's a specific example of it, and now we have a real problem on our hands, and we actually have a regulation that we have been told is not acceptable.
No, I don't think he said that wasn't acceptable. And as I said before, these regulations went before town attorney
It doesn't matter.
and were, well, then, anything we put before the town attorney, you're saying doesn't matter.
No, we know we have more information now at this time than you had then or they had then. Just because there's a regulation in existence doesn't mean that it's legal.
Now, you said we have more information now than was present in the past.
That's true.
What information?
You have legal advice, you've had people in here with constitutional law, you've had 300 pages or so of legal documents.
Not all of which agreed.
Yeah, but they all said,
And you're suggesting that the original attorneys didn't have the Constitution in mind and that they were ignorant of the law.
look, this commission, it's one of the problems I have with this commission. This commission can pass anything it feels like passing. And it would be legal, per se, to pass it. But it doesn't mean we're not going to get sued.
And it
And
doesn't
it doesn't mean it's right to pass it.
And it doesn't mean that if we
We're
were
there to
sued,
protect the people, not to
if we
lord
were
over them.
sued, it wouldn't be approved.
But it shouldn't have to get to that point. That's the problem.
Well, then we do have
Well,
an issue as to how we interpret this.
We have a huge problem with this particular regulation. We know we have a problem with it. And we should put this off until we decide what we're going to do, and the commission votes and has a public hearing on it, and then the commission votes afterwards. Should be put off until then, because it's a problem.
Regulation.
Yeah,
Do you have a
so we
motion?
Well, Ron's not
Need to
seated.
see this.
That's right.
Um,
Anybody have a motion?
I have a question. Can I ask a question before we proceed? Because John asked some unanswered questions. Can I ask through you?
As a matter of fact, you may, because I had a question for John, but
Okay.
go ahead.
Okay, through you, Bob. John, if we asked, and I don't know if this is appropriate, if we asked Tom to answer, is this a political sign? Because he is here, and if we asked, he may divulge to us the size of the sign. Would those two questions, or those two of the questions you're looking to have answered before, as you've been talking?
Talking to me or to John?
I'm talking through you, so I'm not
To you.
Yes.
I am a conduit. Go ahead.
Trying to follow protocol.
What I was saying is that I don't think that anybody ought to be convicted without there being evidence that there is indeed a violation. If somebody comes and pleads guilty, that's a different matter. But simply because somebody chooses to characterize something as something doesn't necessarily prove it. People may be mistaken as a matter of law in their own interpretation of something. But yes, if he came forward and pleaded guilty, as it were, then that would be convincing.
Bob, I go back to you. Before we do anything, do we talk to the... Got it?
Wait till the take place to meet with regulations. I'd like to make a motion that we hold off on this until we go back through our regulations. I make a motion that we don't vote on this tonight, till we go back and go through our regulations. And when we make a change or whatever we're going to do.
There were questions, there are other questions, so before you do that,
There's a motion on the floor, though.
Yeah.
we're not accepting it.
I'll take it back. Go ahead.
Thank you.
I'll give you time.
I think, just to go back to your question about what the issue is referenced in the October 7 letter, which is included in this by reference, basically indicates that the square footage of the sign is in excess of 12 square feet.
Okay, that answers that question. I haven't seen that before.
How about the question on, is it a political, we still have a question on, is this a political sign?
I think by virtue of the fact that on October 7, the town said it was, and reiterated it.
Is it appropriate to make a motion?
Teddy was
Bob, you had another
Teddy,
question.
No,
You want to get it, Nick?
Yeah.
just did.
Oh, okay, thanks. No, I had not seen that before.
Now, based on that, what's your, I'm going to poll again.
I'd say we table this until we know what our reg is going to be going forward, knowing that there's some inconsistencies with what we've got written now.
John?
I disagree. I think we have due process rights here, and this has been going on since October. And I think that Tom has showed up to a bunch of our meetings. I think we owe him a decision on this. To me, our town attorney said that we're discriminating against political signs. I documented it with a regulation. I think we owe due process to either vote up or down on this. I think tabling is inappropriate.
Ted? You want to make the motion?
Well, I know where you're coming from, but I still would like to table it and in our workshop, go through this thing and come out so everybody's happy. And that's the purpose of this commission, all to work together, which we haven't been doing.
So that's your motion?
Yeah.
Second?
I didn't hear everything.
I want to table this until we go back to a workshop on our regulations. Because we can't really
Come up with a firm ordinance.
Yeah, we can't just come up with a set of precedents now.
I'll second that.
Discussion?
I'd like to discuss. The problem with that is that any new regulation does not apply to this sign. So that's my first objection to the motion. The second objection, as I've stated, is that this has been going on for 6 months, and I feel that we have an obligation under the due process clause of our Constitution to do something one way or the other.
Do we know that the new regulations won't apply?
Yeah, it's grandfathered. Anything that would be redone would be grandfathered.
No. Zoning is in effect.
Yeah.
You can't grandfather yesterday if you change it. Zoning is in effect from '69. So
Well, you can grandfather.
Yeah, it is grandfathered. If you change a regulation, it can be grandfathered.
But we might come up with something that will allow him to do what
Right.
we're doing, or maybe he was legal doing what he was doing. I think it's buying time for both of us.
Yeah.
okay. Any more discussion?
I'm sympathetic to the idea of dismissing it. My only problem is that if we do that, it leaves the door open to somebody tomorrow to make the same complaint all over again. Because it is, in theory, still a violation. And so if we table it and take care of it in the regulations, then we've taken care of it. Because we can then dismiss this complaint, and it can never be revived again, because the regulations have changed and it would be a new ball game. Anything else would put Tom in jeopardy of somebody playing with us.
Brian, do you have any input?
Yeah. There's a couple issues that came up. I think what John said is absolutely true. If you dismiss it right now, a complaint could be into the office tomorrow, and we would start the process again, which I'm not sure serves anybody's interest at this point. If right now, the regulations say 12 feet. We could proceed with that. You could also have a notice of possible violation. I didn't interrogate Mr. Harris as to whether he had political motives or doesn't like Mr. Overton's car or whatever his motives are. I think it was common sense that there was some political basis to it. Again, that's maybe for you to interpret. You could, if you want to pursue, we could back off a little bit, notice a possible violation, and entitle him to come to testify, and you could ask him questions about the size of it and everything else. But it sounds like you want to back off more, that if there's a discomfort with the regulation as it is now, then back off and see if you can fix it. But just I want to be clear, if you go through this process and you don't come back with whatever, again, I don't know the exact size of the sign, you don't come back with it being conforming, that doesn't grandfather it, because it would have been established under these regulations, so you could still come back on that. But if if you're uncomfortable with it and you want to change it, just as I'll advise you, again, whatever you change it to, bear in mind that's not just, it doesn't deal with Mr. Harris, it deals with anybody who wishes to do something similar.
I have a question. Is it we're about to rule on something one way or the other. Should we allow Tom to address us? I mean, doesn't he have a right to address us?
You could, if you want to do that, but you see, you're talking two different items here.
Okay.
At one point, I'm hearing that there is a question about the legitimacy of the regulations, and in which case, I don't think him addressing you really makes any difference. If you accept the legitimacy of the regulations and you wish to ask them questions, is it really a political statement? Could you explain yourself? If not, what size is it? You could do that, but when you do that and you find that it does not conform to the regulations, then I think that will mandate you to move forward to an enforcement action. So it depends which way this commission wishes to go, and I'm hearing different vibes here.
Okay, I move the question. All those in favor of tabling this enforcement order, cease and desist order, actually, say aye.
Can I just have a clarification, Mr. Chairman?
Go.
By tabling it, we don't want to, if it's until after a decision is made about amending the zoning regulation, just for clarity, we don't want to keep putting it on the agenda as a tabled item,
No.
because that would just waste everybody's time. So if you be clear about that it not be placed back on the agenda until after a decision or no decision is made about the amendment of the sign regulations, I think that would probably benefit all.
That's kind of what I wanted to do.
I suspected that was the intent, but we don't want to keep putting it on the agenda.
Well, couldn't we do that administratively?
Just as a point of clarification, that's all I'm asking.
You want to modify your motion?
Just what he said sounds good.
Brian, are you asking us to put a date on it?
It's on
No, it's more of a trigger point when you're done considering it. Thank you.
All right, once again, all those in favor of
Wait, we
tabling,
get a second on that.
I seconded it.
Yeah.
Oh, sorry.
all those in favor of tabling the cease and desist order and not including it on future agendas until further notice, say aye. Aye. Opposed?
Opposed.
Yeah, I said it.
Ayes have it. 4-1. Okay.
This is-
I,